Hi, my name is Jonathan Taylor. I am a Title IX advisor, and I'm here to advise you on what to do if you have been wrongly accused of violating your school's Title IX or sexual misconduct policies. So that may mean you have been accused of something like sexual harassment, stalking, dating violence, which is also called domestic violence or relationship violence, sexual assault, or, God forbid, rape. If you have been accused of any of these things, you need to take the process and the allegations very seriously for three reasons. Number one, the consequences of the investigation and the decision at the end of it can be life-altering. It could mean something like suspension or expulsion or denial of employment or denial of professional licensing. It could mean you are referred for criminal prosecution, and it could mean, if you're a foreign student who's there on a student visa, it could mean that you are eventually deported back to your home country. And these are of course, the professional and the academic consequences. There are, of course, social consequences, such as potentially losing relationships and things of that sort. Another reason why you should take the process seriously is because the process is complicated. There are federal laws that govern this kind of thing, federal regulations, state laws, federal court decisions, state court decisions, all that, and of course the school's own policies. So the process is complicated, and it would be unfair for a school to expect you to be able to be aware of all of these things, all of the provisions of those policies and those laws and those regulations, and to be able to navigate them for your benefit on the fly. But of course, a lot of schools do. And that brings us to the third reason why you should take this thing seriously, and that is because too often the process is unfair. Not only for the reasons that I've already mentioned, but because too often there is bias among administrators, among investigators, or decision makers. And unfortunately, numerous students have been wrongly found guilty, which they call finding them responsible, and punished for that. So there are numerous ways in which you can defend yourself, but to do so, you need to take the process very seriously. So when you're taking the process seriously, keep in mind that it's just not enough to tell the school the truth about what happened. And unfortunately, it's not enough to be a good person either. Being a good person is a necessary but insufficient qualification for having a good defense. You also need to present yourself well. You need to make good decisions. You need to take advantage of time-sensitive opportunities. And to do that, you're going to need help, and quite a bit more than you may think. So without further ado, let's get into what you should do if you have been accused of a Title IX violation. And the first thing is you should call your parents and tell them that you have been accused. There are several reasons why you should do this. The first thing is that you need to establish your support network. Your accuser has already established their support network, so you need to establish yours. You need someone who will be there, not just in terms of being an emotional support, but also someone who can be a sounding board that you can just talk to about the allegations, and you can just get a sense of what sounds right, what sounds wrong, that kind of thing. Of course, that is also what an advisor can do in a more professional and strategic capacity. But you also need an emotional support network, and you need someone very close to you. And your parents are going to be almost always the best fit for that. Now, you may not want to tell your parents for several reasons. You may think that the allegations are not that serious, or that you can kind of take care of them on your own. A lot of students have found out to the contrary. Keep in mind that what seems like a small allegation at first can become something much bigger later on. Schools can and often do upgrade or add additional charges to the process as it goes on. And I've seen so many cases where students think they can take care of it themselves, and then they just delay reaching out to anyone for help, and then they find out that they're in over their head, then it's a matter of not just preparing a good defense, but also digging them out of a hole, unfortunately. So in order to defend yourself well, you need to start by establishing your support network. Tell your parents. Your parents will be in your corner from day one, unless there's something quite exceptional regarding your relationship with your parents. I have seen so many cases where mothers and fathers will do incredible research in behalf of their children, and just have their back in so many ways, including financially as well. That's another thing. If there are any expenses related to your case, if you need to move back home because perhaps you were kicked out of housing, that kind of thing, your parents are going to be an excellent resource for you. Now, you may not want to tell your parents because maybe that would lead to talking about the allegations with them. And for example, maybe you were accused of some kind of sexual misconduct, and your defense is that you engaged in sexual activity, but that activity was consensual. And I can understand how, if you were to talk to your parents about the matter, that it may lead to revealing some details about the encounter that are embarrassing, that you would, of course, prefer that your parents do not know. But nonetheless, I would go ahead and just bite the bullet and tell your parents. There is another unspoken or often underappreciated aspect of telling your parents, and that is that whenever you start telling them about what happened, you are subconsciously practicing telling your story. You're going to figure out how to put it in your own words, how to sound authentic, and put things together in a way that is not where you're not contradicting yourself and that kind of thing. All of that is very important to practice. And you do not want the first time that you tell your story to be when you are alone, unpracticed, unadvised, speaking to an investigator in a heightened state of emotional vulnerability. So that's another good thing to keep in mind. Now, if your parents are not available for whatever reason, in that case, I would go for perhaps your closest friend. Just find someone who is closest to you that you trust, and I would start, just start establishing your support network. The second thing that you should do, which is closely related to number one, is choose an advisor. You need someone who is specializing in Title IX, who is experienced, and who you can trust. No matter what Title IX advisor you go with, if they don't specialize in Title IX, definitely don't go with them. If they're not experienced, I would advise against it. And of course, if you don't trust them, I would not go with them either. Federal regulations, for example, state that a Title IX advisor may be, but is not required to be, an attorney. And that is good because a lot of advisors, they can help students who maybe cannot afford an attorney. And that is actually where we come in. We are not attorneys ourselves, but Title IX is our bread and butter. It is something we eat, sleep, and breathe doing. And we aim to serve a lot of students for who simply have no money tree to shake, so to speak, and who cannot afford an attorney. So there are many things that a Title IX advisor can assist you with. I'll go over a few of them here. One of the biggest things is crafting a defense strategy that is tailored to the allegations against you and to your specific circumstances. There is no one-size-fits-all type of defense. Whenever the strategy is being crafted for your defense, it has to be something that takes into account your specific situation. It's not something that you can just look up on the internet somewhere and that kind of thing. A Title IX advisor can also help you raise timely objections to unfair procedures. And you may not even know that you need to raise an objection, that kind of thing. And sometimes if you do not raise the objection in a timely manner, the window is closed, and it could potentially impact the decision that is rendered for or against you at the end of the process. An advisor can also help you with submitting evidence, obtaining evidence, preserving evidence, crafting communication to the school. You may not be sure if a particular way of saying things portrays you in the best light. We would definitely be able to help you with that. You may need accommodations, academic accommodations, housing accommodations, other types of accommodations. Of course, we can help you practice telling your story, what you should include, what you should emphasize, how you should say it, what you should leave out. There are, in so many cases, when students do not have an advisor, what happens is I'm going to tell you, they get in with these interviews, and the investigator, they look like little church ladies. So they feel they get them comfortable and get them comfortable talking, and then they start oversharing. And then before they know it, they start admitting to things without even knowing that they have even admitted to it. Maybe they didn't admit to an act, so to speak, but they admitted to things that could be construed or misconstrued as elements of what they are accused of. And there are so many pitfalls whenever you are going into a meeting with an investigator. You need to know up front how to avoid them. Another area an advisor can help you with is helping you navigate the school's policies. Sometimes schools investigate conduct under a Title IX policy, and sometimes they investigate it under a non-Title IX policy. And the rights that you have for your defense may be and usually are substantially lower under the school's non-Title IX policy than the school's Title IX policy. And the school needs to apply the appropriate policy to the allegations against you. There's been a huge issue where schools inappropriately apply a non-Title IX policy and then initiate what are sometimes sham proceedings against the accused student, and then the student is found guilty and then kicked out, that kind of thing. And so number one, you need someone to help you know what the policies are, to help you object when the policy is being applied unfairly, or when the wrong policy is being applied at all. Another big thing that we help people with is accused students with is investigation reports. Investigation reports are things that investigators compile. They are supposed to summarize the relevant and permissible evidence, and then the parties have a chance to respond to the investigation report. And it's critical to respond to that investigation report appropriately, because the decision maker relies upon that investigation report to render a determination or a decision of whether you are guilty or responsible or innocent, or not guilty or not responsible. And sometimes these investigation reports are riddled with errors. Sometimes they are biased. Sometimes they leave out things that they should definitely include. One of the most common things that I see in investigation reports is investigators failing to follow up on leads that could expose the complainant's narrative, your accuser's narrative, to additional scrutiny. Very obvious things. I could give you examples, but I don't want the video to go incredibly long. Another thing that we will be able to help you with is the hearing. The hearing is like a miniature trial. It comes close to the end of the process, so just before the decision is reached. And it involves things like cross-examination, where the advisor would pose questions of the other party, and that kind of thing. There's a whole element of strategy to that, and how to ask questions and how to not have it blow up in your face, and what questions are permissible and not permissible, and that kind of thing. And of course, you would also be granted you would also have the opportunity to make an opening statement and a closing statement, and those, depending on how those are worded, those can really resonate with the decision maker. So of course we would be able to help you with all of that. And of course, sometimes during the hearing there are procedural irregularities, if you will. Universities may do something that is objectionable. You need someone who has the awareness and knowledge to object on the spot in your behalf, that kind of thing. Number 3, the third thing you should do if you are accused of a Title IX violation, read the school's misconduct policies and save a copy. So you should read the policy because you should have a sense of what the process is like. The school's policy will help you get an overview of the process. It won't really help you with strategy or tactics or anything like that, but it'll give you a sense of kind of how the process works. And you should save a copy because sometimes schools do change their policies midway through an investigation. There have been several lawsuits where schools change their policy in a way that impacts the rights of accused students, and they don't provide notice to the accused student, and then the student's found guilty, and then the student sues, and then they find out, and one of the reasons they sue is because they weren't provided notice, and that kind of thing. So you need to document the policy. You need to save the policy, and you need to start to read the policy and understand how it's, at least how it should be applied, and get a sense of how the process works and how it should be applied. Of course, an advisor can help you more with that. Let's see. Number 4 is expand your support network. A lot of this is just about establishing your support network, your parents, your advisor. And for this one, number 4, I recommend joining Families Advocating for Campus Equality. It is an organization, a nonprofit that was founded by moms of accused students, and they do advocacy for fair procedures, just like we do. And they also assist with, they're essentially a support network for accused students and their families. So they are a great resource, and I definitely recommend joining them. Number 5 is maintain all records. So if you're presented with any kind of records, especially digital records, notices, documents, photos, messages, videos, save those records. Save them in a safe place. Do not rely on the school to keep records. Sometimes they fail to maintain records. Sometimes there was one lawsuit even where the university destroyed the investigation records after the student sued, or when the student threatened legal action. So also, if you need to appeal your decision, the decision in case you're found responsible, then you need to have good records of the proceeding as well. Number 6. This one can be tricky, in some cases tricky, in some cases straightforward. Strategically manage communication. So going forward, assume that anything you say that could be taken the wrong way will be taken the wrong way. Do not engage in further contact with your accuser. Do not apologize for anything, even if you are just apologizing for the situation or for someone's hurt feelings. That could be used to demonstrate that you feel guilty about being guilty. So don't do it. Do not talk about your case publicly going forward. Now that's different if you're talking about your case with trusted, close friends. But definitely do not talk about your case on social media. Be aware that some accusers will try to pressure the people that they accuse, or that they intend to accuse before they've even accused them. Pressure them into admitting, just admit what you did, this kind of stuff in text messages. And they may not even be asking them to admit to the act necessarily, but maybe to a particular element of the act. And even if you don't admit to the act, but just to a particular element of the act, that could be used to make you find you guilty later on. And what some accused students find later on is that at that point, the accuser has special help with an advisor of their own, and they are playing a game and that kind of thing. So definitely do not. But that again goes back to do not do not engage in further contact with your accuser, or someone that you strongly suspect will accuse you as well. Be aware that some accusers also use mutual acquaintances, friends, that kind of thing, to essentially bait people into talking about the case and that kind of thing, and that can also blow up in your face if evidence is later misconstrued or doctored in some fashion. Another thing about managing communication, if you have received a no contact order, and you likely have or will at some point, read it carefully and follow its terms exactly. Sometimes no contact orders are harsh, sometimes they are unfair, but you have to follow it unless or until that no contact order is modified or reversed. Again, an advisor can help here. Another thing is, do not confront someone who is supportive of your accuser. Even if they are a mutual acquaintance, a mutual friend, the school will likely regard this as retaliation, and then that is a separate misconduct charge that can be entered against you. And if you're found responsible for that, then it can be easier for a decision maker to find you responsible for other allegations as well. If you're using a university email address for personal matters, stop immediately. Assume that anything that is transmitted through the university's email can be read by administrators. Now, when it comes to managing social media, it can sometimes be tricky. I've even seen some no contact orders that ordered students to remove certain, like the adverse party, the accuser, from their friend list as connections, remove them as connections from social media, or perhaps mutual acquaintances. You want to be careful here because you don't want to remove your access to evidence. Like just as you should not be talking about your case, it is also to your accuser's advantage to not be running their mouth about the case as well. And perhaps you may have some evidence that can exonerate you if it is on your accuser's social media profile or a mutual friend or acquaintance's social media profile. Perhaps you were accused of something, that allegedly happened a year ago, and there is evidence on your accuser's social media page that can help you. So just be very careful about how you manage communication. You generally want to avoid anyone prying into your account, but you also want to have the ability to access evidence if it can help you. And lastly, when it comes to strategically managing communication, compose yourself. Try to avoid appearing angry, even though you have every right to be, because the reality is, and research has demonstrated this, accused people who present as angry, that makes them appear guilty. Regardless of whether they are guilty or innocent, that makes them appear as guilty. And then that is easy for someone to construe into you having a temper, potentially being violent, that kind of thing. And the last thing, number 7, the last piece of advice for what you should do if you have been accused is pace yourself. It is natural to want this process to be over as soon as possible. I get it. And you may even be misled by a school administrator into thinking that it will be over soon. It is quite common for administrators to say that they want the investigation and all of that to be over in 60 days or 2 to 3 months or something like that. In practice, it tends to take quite a bit longer. So think of it as a marathon, not a sprint, and learn how to pace yourself emotionally as well early on. Sometimes when related to this, sometimes when dealing with these allegations, a lot of accused students can feel overwhelmed. This is especially true if they have delayed reaching out to someone. They delay reaching out. They get in over their head, and they may fear that there is that damage, incurable damage has been caused, something like that. Or they are just, they may see their relationships falling apart because of the allegations. They may be worried about their future falling apart, that kind of thing. I would just make sure to take time for yourself. And don't obsess about these allegations to the point that you become depressed. You have to come up for air at some point. Some accused students, they become withdrawn, they become depressed, and then some of them even lose the drive to engage in their own defense. And that's a very dangerous situation, because then it's hard for anyone to help them at that point. So again, pace yourself. Take steps early on to take care of your mental and emotional well-being. Be prepared to lean on your supportive relationships, your parents, your close friends. Take time for yourself to enjoy your hobbies and take a break when there's nothing urgent to attend to. And then come back fresh with your advisor to engage in your own defense. So those are the suggestions. Of course, there's a lot more to this process. This is just for what to do at the outset when you learn that you've been accused. There is a lot of now defending yourself successfully against a Title IX allegation can be a lot of work, as you are probably starting to figure out at this point. But it is worth it. And remember that no matter the outcome of the case, remember that there is always a future ahead of you. All right. So if you have been accused, please give us a call. Please go to our website, title9forall.com. That's the Roman numeral 9. So it's titleixforall.com. And again, if you would like to hire us to be your advisors, we can definitely help you craft a good defense strategy, help you with those interviews with investigators, help you with the investigation report, help you during the hearing. And if it comes to it, help you on the appeal and all sorts and everything in between. So thank you very much for watching this video. I hope you don't need it, but if you do, give us a call.